The 125 proceedings, when it is filed, this decree was not passed. Decree is for 28 lakhs. MFA, the interim order of permanent alimony has been stayed subject to 7 lakhs. When a MFA is pending, they can seek an application for modification, seeking require more amount.
No, once the MC is disposed of and 28 lakhs permanent alimony is fixed, no, it doesn't remain to be the same. And 7 lakhs you have already received.
Yes.
So why should these proceedings be continued? You're also asking for enhancement of the alimony.
Yes.
Yes. So if the court feels that what it is, it could have been decided.
In this application, the respondent has stated that she has earlier filed a petition under so and so for a dissolution of the marriage, and the petitioner herein and the Honorable Court judgment and decree dated allowed the petition by dissolving the marriage. At the same time, awarded permanent alimony of 28 lakhs to the petitioner. Hence, he filed MFA number before this Honorable Court, Honorable High Court of Karnataka at Bengaluru, challenging the judgment and decree in respect of the permanent alimony part, and the Honorable High Court issued interim stay order dated 21/9/2020 and directed the respondent to pay a sum of rupees 7 lakhs to the petitioner within a period of 6 weeks from the date of the said order. Therefore, the respondent paid 7 lakhs to the petitioner by a demand draft dated so and so, so and so, so and so. And the petitioner, in spite of receiving the notice in MFA by the Honorable High Court of Karnataka, he has neither preferred an appeal nor appealed before the Honorable High Court, nor challenged the interim stay order in the MFA. Further, he states that the application that the petitioner suppressing the fact that granting of permanent alimony to the tune of 28 lakhs and thereafter the receipt of 7 lakhs from the respondent has filed the petition seeking maintenance. Further, he states that the wife who has granted the permanent alimony under Section 25 of the Hindu Marriage Act cannot seek maintenance under Section 125 of CRPC, and therefore, under the changed circumstances, he prays for a dismissal of petition by the petitioner. The petitioner has filed objection. Next, reasons. Next page 43, para 6. The main contention of the filed by the petitioner seeking direction to this court, respondent to pay the monthly maintenance of 50,000 to the petitioner, and the case stands posted for recording of respondent's evidence after close of the petitioner's evidence. At this stage, this instant application is filed by the respondent seeking dismissal of the main petition under Section 127(2) under the changed circumstances in the said application. The submission of the learned counsel for the respondent applicant is a main object of 125 is to provide immediate relief to the applicants to be destitute a wife and the parents or the children of the respondents or their survivor. Here, in this case, the wife has been awarded 28 lakhs permanent alimony, and admittedly, out of the said amount, 7 lakh is already paid to the petitioner herein, and therefore, the petitioner is not a destitute wife struggling for her survival, and she further argues that parties are no more husband and wife and they have no children out of the wedlock, and the respondent husband it is also human trying hard to survive, and he cannot be allowed to squeezed by the wife according to her whims and fancies. She further argues that so seeking permission to court alter the objection so and so filed by the husband and include a counterclaim for the permanent alimony which was rejected by this court, and she had filed a writ petition before the Honorable High Court against the rejection of the permission to amend the suppressing the fact pendency of in the instant petition seeking maintenance, and hence nothing in this fact. The Honorable High Court has dismissed the writ petition, slapping 10,000 costs upon her for not approaching the Honorable Court with the High Court with the clean hands. She further adds that the petitioner being the attitude in filing one of the other cases only to squeeze the respondent and harass him. Finally, he argues so and so. Judgment, para 7. For contra, let the ranges and everything is quoted. The reasons, para 8. As rightly pointed out by the learned counsel for the respondent husband, 125 provides for a speedy and effective and inexpensive remedy against the persons who refuse to maintain or neglect to maintain the persons legally dependent upon them. A wife who is unable to maintain herself and her husband who also sufficient means neglects to refuse to maintain her may make an application under Section 125 of CRPC and seek an order of maintenance. Undisputedly, the petitioner has filed the petition seeking maintenance when the petition filed by the MC seeking dissolution of their marriage was pending before this court. Hence, the first and foremost contention that the respondent that the petitioner herein was suppressed the fact of granting maintenance permanent alimony of 28 lakhs and her receipt of 7 lakhs from the Karnataka does not hold water. True, the Honorable High Court has slapped the petitioner with the costs of 10,000 while dismissing the writ petition filed by her against the order of rejection of amendment application, which was filed her subsequent to filing of so and so, seeking maintenance by suppressing the same. But but this case was filed by her before this honorable court much prior to the judgment and the order passed in MC number so and so. And hence, there is no question of suppressing the said fact before this court. Now, coming into the claim of the change in circumstances, here the judgment and decree passed by MC so and so is challenged before the Honorable High Court of Karnataka by both the parties herein with their respect to their respective claims. Therefore, the order of the court dissolving the marriage between the parties does not attain finality on the sole ground that the appeal continuation of proceedings of the lower court and also the order of granting permanent alimony. Admittedly, the parties are in dispute since 2016 and the petitioner has received 7 lakhs from the respondent in 2020. The contention of the learned counsel for the respondent is that since it was paid under 7 lakhs by the respondent, she ceases to be a destitute and there is no more in desired necessity of money for her survival. The object of 125 is to provide immediate relief. The Honorable Supreme Court has time and again explained the meaning of the scope of survival and also held that even the wife is earning, it cannot operate as a bar from being awarded a maintenance by the husband. The court has to determine whether the income of the wife is sufficient to.
Yes, I've seen.
Yes.
So I'm asking you, when you filed this 125 CRPC proceedings, did you disclose about the permanent alimony that's granted to you in the MC and also your 7 lakhs that is granted in the MFA?
No.
Why?
No. It was, let it not be in a confusion of state of facts. The 125 proceedings, when it is filed, this decree was not passed.
That's what I'm saying.
Yes, correct.
Even before this MC is decreed, this is filed. That's what the court observes.
That's the
I'm
fact.
referring to
That's
that.
the fact.
Uh,
MC
So then
order
the court said question of disclosing all that will not arise in this petition.
disclose now as a matter of fact between the list between the same parties. Now, admittedly, there is a decree. Decree is for 28 lakhs. MFA, the interim order of permanent alimony has been stayed subject to 7 lakhs. Nothing prevented the wife to file an application for seeking modification. But it is the 125 proceedings is only for a destitute wife for immediate relief. No interim maintenance has been granted by the trial court by filing an application seeking interim maintenance. It is stood for evidence. Now that statement that we filed an application. Now for what purpose? When a MFA is pending, they can seek an application for modification seeking require more amount. Nothing prevented. Now why should the proceeding should be continued?
But the reason is because there was emergency situations, my lords, where we could not file an application in MFA. We filed 125 proceedings because of emergency situations. my lords.
That you have filed 125, much prior to your MC is disposed of.
Yes,
Now, once the MC is disposed of and 28 lakhs permanent alimony is fixed,
Yes.
no, it doesn't remain to be the same.
Yes.
And 7 lakhs you have already received.
yes,
So why should these proceedings be continued?
my lord, because the last amount which you have received, my lords, is in that.
No, why don't you ask the court? Why don't you ask the court where MFA is pending? No, once you have the permanent alimony, again, you can't ask for 125 proceedings. So now the court has only asked for depositing 7 lakhs. No, it's been pending from a long time. We could have asked, no, that 7 lakhs that is, that is deposited by them is not sufficient. So deposit another 7 lakhs so that it is pending whatever is the decision of the court. That would have been more easier way for you to deal with it. When was the MFA filed?
Lords, MFA was filed in
2020.
2021.
No, you had like 3 years time. When was this order passed?
This also was passed, my lords.
Much after
That is because
2020 MFA.
we have filed 2020, they have filed, my lords, 2021, we filed.
You have filed.
After that, my lords, in that 2020 only, we got 7.
You're also asking for enhancement of the alimony.
Yes,
Yes. So if the court feels that what it is, it could have been decided, no, you have a permanent alimony. Now you will have 125. Then the court will confirm, this court will confirm, for example, the 28 lakhs. Then again, whatever that has been paid to you during the pendency of this, again has to be relooked
Adjusted.
into. Some order needs to be passed, which is altogether a separate proceeding, sir. then we'll give you, now it has come up for the final hearing. If not, now even at this stage, if the things are not being decided, file an appropriate application. That I'll observe. Because anyhow, again, going back, again, this proceedings taking forward, your client will not get a relief.
It may be posted for tomorrow, sir. Seek instruction.